Welcome everyone to lecture number 39. Okay, in the lecture 38 we have discussed the amendment procedures, the type of amendments, what is amendments, and why this amendment has been introduced in the constitution. Okay, and whatever the things that we have discussed in lecture number 38, it was like a vague intro of all those things, just have an introduction that these are the things that is there. It was crisp and clear, like these are the points. Okay, what are the stories behind that, and what are the aspects on those things, what are the thinking, what are the thoughts processed behind those issues and all, the types and what are the topics we have discussed. All those things now we are going to discuss in detail. Okay, 37 was like, whenever we are going to study any new topic, so it is like, the student should be aware what are the things that we are going to study. Okay, so if they are aware of the topic, so it has been seen that a student used to make a more concentration on those aspects. Okay, so that's why we have taken in that way. So now we are proceeding on the this amendment of the constitution, all the concepts and all in detail. Okay, so yeah, so we'll begin with the history section. So how it happened. So Kesavananda Bharati case we have discussed that in that it has allowed that through Article 368 we are allowed to amend any part of the constitution, but we can't amend the basic structure of the constitution. Okay, that was the main verdict, that was the term that was coined at that time, and now it's still it is there. Okay, so now we'll see what are those aspects. Okay, yeah. Okay, so what happened in 1973, Mysore was renamed as a Karnataka. I'm going to more in detail in okay, historical section as well. Okay, Mysore was renamed as Karnataka. Okay, now within the within that Mysore, that project Tiger to Save was there. Many things were happening at the time. At the time, Bollywood gave India chocolate hero, that was Rishi Kapoor. Okay, so Rishi Kapoor was at the time in famous. He was called as a chocolate boy, chocolatey boy. Okay, and one was that it was in Sachin born in this year. Okay, and Kesavananda Bharati case, judgment delivered by Supreme Court that saved Indian democracy, happened in that time. Okay, so these were the many things were happening in the year 1973. One was that Mysore was named as Karnataka. Project Tiger to Save was running. Rishi Kapoor was in the news, and Sachin born during that period. And Kesavananda Bharati case, judgment happened, was given by the Supreme Court during that time. Okay, yeah. So making any change to the constitution, making any change to the constitution is called as the amendment done by the parliament. Okay, so you must be worrying why I have told these many things. I just want to be make you aware, more interesting, that what are the things that happened in the 1973. Okay, and we have to be we have to focus on our important thing, that Keshav Nanda Bharati case. This is the point that we have to focus. Now, making any change to the constitution is called amendment of the constitution. We know that an aspiration of a people changes, and should the constitution should also be changed. Okay, as the period evolves, as the time lapse, people requirement changes, people aspiration changes. Okay, and as per that, law should also be get changed. So Pandit Jawaharlal Nehru, he said that constitution should not be so rigid that it cannot be adapted to the changing needs of the nation development and strength. Pandit Jawaharlal Nehru he said that constitution should not be so rigid that it cannot be adapted to the changing needs of the nation development and strength. Okay, so he was also in the support of that amendment should be there. So it is just a point that why amendment was introduced. Okay, so at that time Pandit Jawaharlal Nehru said that it should not be rigid, and further there is a point that constitution should not be also flexible, that it can be easily amended. Okay, so any popular demand for changing the system should be capable of realization and should be capable of changing in the constitution. B.R. Ambedkar views also said. What was the B.R. Ambedkar views? B.R. Ambedkar views was that there are many who will not be happy with the constitution, and if you are not happy with the constitution, so all you need to get 2/3 majority, he said majority in the parliament, and change the constitution. If you are not able to get the 2/3 majority, if it is not achieved, it means only you are dissatisfied. It means that you are dissatisfied. It is your problem. It's not a people problem. If it was a people problem, then you must be getting a vote more than 2/3 of the majority. Okay, if you are unable to get a vote with the 2/3 majority during the amendment of the constitution, it means that you are dissatisfied, and your satisfaction will not be kept in front of the larger public interest, because the people who are sitting in the parliament are chosen by the public itself, Indian citizen. Okay, if they are unable to get the majority in the parliament, it means like the majority of the Indian citizens don't want to amend that particular part of the constitution. Okay, if they are able to get the that special majority, if they are able to prove that a special majority, so it means that yes, people are able to change the constitution. Okay, and you are satisfying the people, and it is the requirement of the people that we are able to change the constitution. So that was the view of the B.R. Ambedkar. Okay, so the word law does not include an amendment of the constitution made under the article 360. So one point was that we have seen the definition, the term, the law in the starting of the discussion of the articles. Okay, so nobody can change the law or meaning of the law also. Okay, that kind of amendment can also not be done. Supreme Court mentioned in the 1951. Supreme Court said in 1951 that first thing, the word law does not include an amendment of the constitution made under article 368. As I have told you initially in the previous lecture, that whenever we are going to amend the constitution, it can be done with the three ways. Amendment is done actually with the three ways. Okay, in the first two ways, it is done by the article 368. For that you have to get a special majority. Okay, and if you are going to change a federal structure of the constitution, so in that case a special majority with the 50% state ratification is required, and that state ratification will be passed by the simple majority. Okay, so that are the two types. So within the two types, article 3 there comes another article 368. Okay, So that the Supreme Court mentioned that you can't be able to amend the meaning of the law that is mentioned in Article 368. And yes, another type of amendment is the simple majority, whenever the state formation is there or state division, the alteration of the boundaries and those things when happen. So at that time, constitution schedules are also get updated with the state names and all. So in that case, it requires simple majority. Okay. So so this was the starting. This was the view, juristical view. So what happened from 1951 to 1967? We are going to see in this lecture. Okay, from 1951 to 1967. From 1951 to 1967. What are the things that happened? Okay, two Pandit Jawaharlal Nehru government passed law. Okay, two laws were passed. Let me change the color. Two laws were passed by Pandit Jawaharlal Nehru. Okay, what are the two laws? First was Jamindari Abolition Act, and we have seen that Jamindari Abolition Act was becoming unconstitutional. So for that, government has done many tricks and all. So we have seen all those things. Okay, so right now we have just know that two laws were passed by the Pandit Jawaharlal Nehru. One was Jamindari Abolition Act and another was Land Reform Act. Okay, that were abolished. So it was declared as unconstitutional. These two law, when it was passed, it was declared as unconstitutional. Okay, in 1951. It was that the Supreme Court said that you are trying to give an effect to DPSP, Directive Principle of State Policies, on the condition of fundamental right. Okay, it was that you are giving priority to DPSP on fundamental right. Okay, in that way they have added multiple sections. That under Article 9, if in Schedule 9, if anything is mentioned, so that no, that particular fundamental right will not be applicable on that. So that kind of amendment happened during that time. We have discussed all those aspects in the previous session. Please go with that, then you will be able to connect the dots here. Okay, so unconstitutional in 1915, DPSP fundamental right. Okay, so it was declared as a unconstitutional. So then Parliament amend the constitution. Then Parliament amend the constitution, and it added. Then Parliament, after that, when it was declared unconstitutional, this act, Pandit Jawaharlal Nehru wanted to implement this act at any case. So what happened then? Parliament amend the constitution. Okay, and it added 31A and 31B to the constitution. Okay, and added 9th schedule. Original constitution have 8th schedule only. Okay, currently it has 12th schedule. During that period only 9th schedule was added. Okay, and they mentioned that within the 9th schedule, whatever the things will be added, whatever the things is going to happen, it will have no judicial review. That court can't interfere if anything is added under the 9th schedule. Okay, this was the amendment that they did. Okay, now what happened after this? After this, it was challenged in the court. It was challenged in the court. Okay, in the which court? In the Shankari Prasad Deo versus Union of India in the year 1951. Okay, now this went to the court. Supreme Court said that all those changes are constitutional. Whatever the changes that they have made, whatever the amendment is done here is constitution, is constitutional amendment act by the legislature. The Supreme Court give a allowance that okay, yes, whatever they have done is correct as per the constitutional amendment, as per the constitution provision. They have done it and it is right. Okay, no question was raised. Okay, yeah, they added that in article 13 to law can't be deleted or modified, and article 13 clause 3 defined the law also. Okay, so how is it possible? Supreme Court said that the law does not include an amendment of the constitution made under the article 368 at the time. So like within the article 13 clause 2 it was mentioned that laws can't be deleted or modified. Okay, law can't be deleted and modified, and article 13.3 they were defining the law also. Okay, so how this can be possible that even it is not deleted and modified and definition is also there. So Supreme Court said that the word law does not include an amendment of the constitution made under the article 368, and parliament can make any changes. Okay, and then that there was a verdict that happened. Supreme Court said added into that amendment done above is constitutional. Okay, that's what, just take it this concept here. Okay, after that, after this period, again one case came. What was the case? Golaknath case in 1967 versus the state of Punjab. This case happened. Now this time Supreme Court completely changed the judgment as comparison with the this Shankari Prasad Deo versus Union of India case. Here the judgment whatever the given here, it completely changed the judgment whatever the judgment was given in this case. It mentioned that fundamental rights are beyond the amendment of the parliament. Here in this judgment court said that fundamental rights are beyond the amendment by the parliament. Article 13 clause 3 also include constitutional amendment. Okay, and article 368 cannot amend the fundamental right of the constitution because fundamental rights are beyond parliamentary amendatory power. That was the verdict that was given by the Supreme Court, that fundamental rights are beyond the amendment of the parliament. Okay, article 13 clause 3 also include constitution or constitutional amendment. They mention whenever the they were amending in the previous amendment, they mentioned that they can't amend the this particular fundamental right. Okay, so it said that Supreme Court said no, everything is constitutional amendment is there, and but cannot amend the fundamental right. Okay, so article 368 cannot amend the fundamental right of the constitution because fundamental rights are beyond the parliamentary amendatory power. Okay, Now, Supreme Court was asked if Article 368 has the procedure to amend the constitution, then Parliament also has the power to amend the constitution. Okay, the Supreme Court Article 368 title only talks about the procedure for the amendment, not the power of the Parliament to amend the constitution. Okay, so when the Supreme Court gave the judgment that within this also Supreme Court added that Article 368 cannot amend the fundamental right of the constitution, because fundamental rights are beyond the Parliament amendatory power. Okay, so when this judgment was given, so now question was raised that Article 368 itself gives the procedure to amend the constitution. Okay, the Supreme Court was asked that if Article 368 has the procedure to amend the constitution, then Parliament also has the power to amend the constitution. Okay, this question was asked. Okay, generally what is that if in the Article 368 there are procedures and steps have been mentioned that how the constitution is going to be amended. So Supreme Court was asked that when this procedure is given under the Article 368, then Parliament has the power to amend the constitution. Okay, Supreme Court can't tell that we can't amend the fundamental right and all. Okay, Supreme Court replied that Article 368 titles only talks about the procedure. It only talk about the procedure to amend the constitution, not the power of the Parliament to amend the constitution. Understood? That article Supreme Court said that yes, you are correct, Article 368 gives the procedure, not about, it is not talking about the power of the Parliament, that you have that power, you can do so. It only talks about the procedure and how you are going to amend the constitution. It does not give the power to Parliament to amend the constitution. Okay, and Supreme Court directed that if you want to amend the constitution, you are free to do so, but at any case you are not going to amend the fundamental right of the constitution. Okay, yeah. So Supreme Court was asked by the government, then this procedure, whatever the procedure, now this question was raised that Supreme Court replied, then again question came to the Supreme Court that when, so whatever the procedure is mentioned under the Article 360, it is for whom? The Supreme Court replied that we don't know, maybe you can set up a constitution assembly and this constitution assembly will follow that procedure. The Parliament does not have a power to amend the fundamental chapter at any case. Okay, Supreme Court clearly mentioned that you don't have a power to amend the fundamental rights and all at any case. Okay, now we'll move ahead to Constitutional Amendment Act of 24th Amendment. Okay, 24th Constitutional Amendment Act of 1971. In 73 Kesavananda Bharati case happened. Okay, so now in 24th Constitutional Amendment, what happened? The Parliament amended the Article 13 of the Indian Constitution. Okay, within this, Parliament amended Article 13 on the Indian Constitution. Okay, and it added and added Article 13 clause 4. There was explicitly mentioned that nothing in the Article 13 shall apply to an amendment of the Constitution made under the Article 368. So Article 13 clause 4 was added, that whatever the things is mentioned under the Article 13 clause 4 is not going to be amended under the Article 368. Whatever the amendment is mentioned in Article 368, it can't be do so. The amendment can't be done to the Article 13 clause 4. Okay, this was the Constitution Amendment Act passed during that time. So another clause was added in Article. These things were added. Article 13 was added. Article 13 clause 4, and within Article 13 clause 4 was added. Within the Article 13 clause 4 was added. Now another thing was added. In 368, clause 3 was added. It was added in Article 368, which provides that nothing in the Article 13 shall apply to an amendment made under the article. And now here also they added that whatever the things is going under the Article 13, that is not going to be added with the Article 368. Okay, they added this thing. So in the 24th Constitutional Amendment Act, this happened. Now we'll move ahead more. So in Golaknath case, Parliament were questioned how you can do this, where Supreme Court said that Article 368 said procedure, if you can't change the fundamental right. Okay, we have seen. Then Parliament substitute procedure for the amendment of the Constitution with the power of the Parliament to amend the Constitution and procedure therefore. Okay. Now another change happened in 1971 as a 25th Amendment Act introduced Article 31C. Through the article, Parliament tried to give 2 DPSPs primacy over 3 fundamental rights. And another change happened in 26th Constitutional Amendment. We have seen all those things in the previous lecture, okay, when we are discussing the DPSP and all. Okay, another change, 26th Constitutional Amendment Act passed in 1921, where it was done by the Indira Gandhi government, abolition of privy purse. Okay, this happened. And again 29th Constitutional Amendment Act happened in 1972, where Kerala Land Reforms Act placed in schedule. So Kerala state legislature passed a law where you can acquire any property even if property belongs to religious institution. Kerala government received legal advice that you can't do this. In Golaknath case 1967, judgment prohibited the legislature to snatch fundamental right of any citizen. So snatching Article 26 is unconstitutional. Okay, so then Kerala government requested Parliament to keep the Kerala Land Reform Act under 9th schedule. Okay, they requested that keep our Kerala Land Reform under 9th schedule. And what was under 9th schedule? Whatever the things is going to be added in 9th schedule is can't be question can't be amended, judgment that judicial review can't be happened, that kind of things that they added. Okay, so now all these amendments made significant changes in the Parliament even after the judgment of Supreme Court Golaknath versus State of Punjab in 1960. Those things happened. So all these amendments were challenged under Supreme Court. First challenge came from Kesavananda Bharati. So what was happening, whatever the thing, just now you have seen that multiple I have spoken, that amendment happened, this amendment happened. So it was that in Golaknath case, Supreme Court clearly mentioned in 1967, Supreme Court clearly mentioned that you can't make DPSP superior than fundamental right. And after that, there are multiple constitutional amendment happened challenging that thing. Okay, so now what happened after that? These all things were concluded. These all things were concluded and challenged under the Supreme Court that these many things are happening, and this is challenging the Golaknath versus what the Supreme Court judgment has given. These things are happening continuously. What is the final thing? We have to become at conclusion. Okay, we are just playing with some of the loopholes from the Constitution. Okay, so that happened. That after in the 1973 Kesavananda Bharati case happened. Okay, so earlier it was decided to challenge from Article 21, but later it was decided from Article 26 that they are going to challenge. So Madhav Raja Scindia challenged 26th amendment, and various things were challenged. So all these cases have only one question: do the parliament has the much power that it can change any law or rights from the constitution? That was the question. That parliament was continuously playing with the constitutional amendment and all. Okay. Supreme Court clubbed all the cases and their issues, then take the case Kesavananda Bharati case versus State of Kerala in 1973, and it was the landmark case in the history of India. And still, this 1973 judgment is taught to all the Indian citizens. Okay, in political science. So it was the largest number of judges ever during that time. Largest number of judges bench it was there. Largest it was 13. Total 13 judges were there in this case. Okay. It recorded number of days this case ran. It was 68 days recorded case, number of days, longest ever running case at that time. Okay, it was the second longest judgment running case was the Aadhaar one. Okay, Aadhaar issues and all. Okay, so just forget about it. Okay, so it was the longest ever running case at the time. The Attorney General of India compared comparatively analysis of the constitution by 71 countries and explaining the amendment procedure of the 71 countries of the world. 703 judgment page was the judgment that was given under the 703 number of pages. Okay. In plain reading the original constitution, there was no any restriction to the power of parliament in the amendment of the constitution. So earlier, if you read plainly, like what are the things written in the constitution, you will go through it. Okay, yes, it is nowhere mentioned that is there any restriction to amend the constitution. Okay, but in the judgment of Kesavananda Bharati case, Supreme Court said yes, parliament has the power to amend the constitution, even fundamental right they can do that, but parliament does not have the power to destroy the basic structure of Indian constitution. Okay, parliament does not have that power. Parliament can amend even the fundamental right, parliament can amend anything, but at any case they don't have the power to destroy the basic structure of the Indian constitution. This was the biggest judgment that was given ever. Okay, it means that you can't change the foundation of a building. Okay, if you can change it, it will be a different building. Once a building is built, it builds upon a certain foundation. Okay, and if you are trying to change the foundation itself of the building, then building will be the completely different building. It will not be the same building. So that's what Supreme Court said, that if you are trying to change or play with the basic structure of the constitution, if you are trying to change that thing, ultimately our constitution will be destroyed and it will be a completely different one. Okay, so you don't have a power to change the basic structure of the constitution. Okay, so this judgment was given very thin wafer. It was given by total 13 bench was there, 13 members were there, and the judgment came with 7:6 ratio. Okay, this was the classic example of judicial overreach. Okay, and this case saved Indian democracy. Okay, so this is the importance of this Kesavananda Bharati case. So if you want to hear a story behind that, okay, I will tell you that as well. Okay, see. So Indira Gandhi, when contested election, her opponent was Raj Narayan. Okay, and Raj Narayan lost at that time. Okay, and Indira Gandhi won. Okay, so he filed a case in Allahabad, and Indira Gandhi has misused the government machinery at the time. She has practiced electoral malpractice. Okay, Allahabad. So he went through all the evidence and declared, yes, Indira Gandhi has done election malpractice. This was declared, okay. She is guilty and will be disqualified. So Indira Gandhi was the first sitting prime minister to be disqualified from the post of uh, by the Allahabad High Court, okay. Indira Gandhi became the first sitting prime minister. Understand? Are you getting that? So that Allahabad High Court said that yes, she has done some malpractice in the election, and it was found guilty, and due to that, Indira Gandhi should come out of his position, prime minister, and she should be convicted under it. Okay. So later on the case, when this went to the Supreme Court, like this was running into the High Court of Allahabad. Okay. Then it went to the Supreme Court, and the judgment was stayed. Okay. And Supreme Court, till then Indira Gandhi continue to be prime minister, but she can't vote in Lok Sabha. Okay. That judgment, whatever given by the High Court, it was keep on hold. Okay. And Supreme Court said that Indira Gandhi can be at a position of prime minister, but she can't vote in Lok Sabha. If anything bill has to be passed, she will not have any right to vote and all. Okay. Then after, emergency was imposed in the country. Various changes happened in the constitution. Among them emergency was declared in the constitution. Okay. Then 39th I guess amendment happened and all. Okay. No, remove that part of 39th and all. I'm not sure about that. Okay. So in this 39th amendment happened. In this amendment, no challenge was filed in the court regarding the election of the president and the vice president, speaker of the Lok Sabha, PM, on the ground of electoral malpractice. She mentioned that amendment she added. She done one 39th constitution amendment. Okay. In that 39th constitutional amendment, she added that no challenge can be filed in the court regarding the election of the president, vice president, speaker of Lok Sabha, and prime minister on the ground of electoral malpractice. Okay. Just remember what I'm trying to say. See, just before that, High Court found guilty. Indira Gandhi was found guilty in the electoral malpractice. Okay. And after that, she challenged that judgment in the Supreme Court, and Supreme Court kept that decision on hold, and Supreme Court said that yes, Indira Gandhi can be currently on the prime minister position until this case is going to be resolved or judgment is going to come, and even after that she won't be able to vote in the Lok Sabha. Okay. And after that, what Indira Gandhi did, Indira Gandhi changed the constitution, amended the constitution. In that constitution, she mentioned that no challenge can be filed in the court regarding the election of the president, vice president, speaker of the Lok Sabha, and prime minister on the ground of electoral malpractice. She added that. Okay, in the 39th constitutional amendment. After that, again 41st constitutional amendment happened. It says that no case, whether it is civil or a criminal, can be filed against president, governor, and PM even after they are removed from the office. Now, after that, what she is telling that, okay, when she is in position of PM. Okay, till that time she mentioned that if she get chosen as the PM and all, then no case can be filed against her. Okay. After that, she added again in the 41 constitutional that even after she come out of that position, that even after either kind of president, governor, or PM, even when they come out of that position, they cannot be no case can be filed on the civil or criminal case against that person. Okay, even after they are removed from the office. It means like entire life. It means what amendment she did? Entire life immunity, she did. Okay, entire life. Once you have become president, governor, or prime minister, you will get entire life security, immunity from any case. Either it can be civil also, criminal case also. It means that she can do murder also, she can kill someone any else also, nobody can touch her. Okay, even if she is not a PM and all. Okay, that kind of amendment she did. Both the amendment 31st and 41st, 31st and 41st, whatever I have discussed. The 41st was that even criminal civil law, even when she is not in the position of president, governor, or PM, if in the past he has become, then after also he can't be, no case can be filed against that person. And in the 39th, it was that no challenge can be filed in the court regarding the election of the president, vice president, speaker. That it was that in the 39th constitutional amendment they told that no electoral malpractice case can be filed against a PM, president, governor, speaker of the Lok Sabha. Okay, so both these cases, 31st uh, and 41st was challenged. Okay, sorry, 39th and 41st were challenged. Yeah, so Supreme Court said that it is unconstitutional. This, whatever the amendment was made, it was declared as unconstitutional. It was unconstitutional because it violates free and fair election. Okay, free and fair election is the basic structure of the constitution. Okay, thus Kesavananda Bharati case saved the Indian democracy. That's why it is mentioned as it saved the Indian democracy. See what kind of judgment what kind of amendment Indira Gandhi did. She want complete immunity. Whenever whatever the case was going to be filed against her, she was telling that we'll change the, she is doing that. It was not telling, she is doing that. She was amending the constitution that no challenge can be filed if even she has done a malpractice in the electoral things. Earlier it was like ballot system election used to be happen. Remember that? Now we have a electronic system voting, right? EVM machines and all. But earlier at that time ballot system voting used to be happen. She did malpractice, electoral malpractice, booth capturing, and all those things happen, and it was proved against her. So she was found guilty. Okay, so what she did, she amended the constitution that no challenge can be filed in the court regarding the election of the president, vice president, speaker of the Lok Sabha, and PM on the ground of electoral malpractice. She was charged against it, thus she changed the constitution. Again, after that, she amended the constitution that no case, whether it is civil or criminal case, can be filed against president, governor, and PM. Not even at the position, even after them when they are removed from their office, then also no things will be no case can be filed against them. It means that once you have become president, governor, or PM, you are completely immune to the life. That kind of immunity she mentioned, okay, in the constitutional amendment. And that's why Kesavananda Bharati case became called as this judgment saved the Indian democracy, because the ruling party was completely twisting as per their own will, selfish kind of things. We can tell that it was not for the people of India. And at that time, Supreme Court emerged as the savior of the Indian democracy. And Kesavananda Bharati case said the judgment that you are disturbing the basic structure of the constitution. Whatever the constitutional amendment you have done in the 39th and 41st amendment, it will be declared as null and void. It is against the it is unconstitutional. Okay, so this was all about in this lecture. I hope you have understand. If you have any doubt, please comment in the video section. If you want to connect with me on social media handle, please connect with me. Thank you.